Judgment in the matter of the Secretary of State for Transport against Curzon Park Limited and others.
Lord Sales will explain the judgment.
This case is concerned with the rules governing the calculation of compensation under the Land Compensation Act 1961 when land is subject to compulsory purchase by the state. The land in question comprises 4 neighbouring parcels of land in Birmingham. The parcels were subject to compulsory purchase for the purposes of construction of the HS2 railway. The basic rule under the 1961 Act is that the measure of compensation is the open market value of land if sold by a willing seller. The landowner is also entitled to compensation for enhancement of the value of the land resulting from actual or prospective planning permission for its development, including if it is suitable for appropriate alternative development. The Act specifies a set of assumptions on which this is to be assessed. If there is a dispute about what qualifies as appropriate alternative development, the landowner may apply to the local planning authority for a certificate of appropriate alternative development, which I will refer to as a CAD. The issue which arises on this appeal is whether, in determining an application for a CAD for a particular parcel of land, the decision maker may take into account CAD applications or decisions which relate to the development of other land nearby. So, for example, if there is one particular form of alternative development which would be particularly valuable in a relevant urban area, and 4 parcels of land which would be suitable locations for it, is the compensation payable to be increased for all of them, even though in reality only one of them could have been used for this development? In this case, there are 4 neighbouring sites which were acquired by compulsory purchase. Each landowner applied for a CAD. Birmingham City Council, as the local planning authority, considered each application in isolation. At this stage, the Secretary of State's contention was that each application for a CAD should be treated as if it was an application for planning permission in the real world. The City Council rejected that approach, and also rejected the contention that the potential cumulative impacts of all the applications for CADs should be considered. The Secretary of State appealed to the Upper Tribunal. The Upper Tribunal again rejected his contention that each CAD should be treated as if it were an application for planning permission in the real world. It also rejected his contention that each landowner was liable to be overcompensated unless the cumulative effect of development, which had or was likely to come forward on neighbouring sites, was taken into account. The Secretary of State appealed to the Court of Appeal, once more making both these arguments. The Court of Appeal again rejected both arguments. It relied on a feature of the statutory scheme, which said that it had to be assumed that the proposed scheme of development, for which the land had been acquired, had been cancelled on the launch date. On that basis, reasoned the Court of Appeal, it had to be assumed that no applications for any CADs would have been made. Therefore, information in the CAD applications has to be ignored, compensation for each parcel of land has to be approached in isolation, and any cumulative effects of possible development of all 4 parcels of land should be ignored. The Secretary of State has appealed to this court. His argument on the appeal is significantly different from what it was previously. He no longer says that each application for a CAD has to be treated as if it were an application for planning permission in the real world. However, he still argues that when assessing the compensation for each parcel of land, it is necessary to take into account the development opportunities for the other parcels. It's therefore wrong to look at them in isolation and to award compensation on the basis that each of them could have been used for particularly valuable development, even though in the real world, under application of the usual planning rules, only one of them could have been. This court accepts this modified argument of the Secretary of State. To this limited extent, this court unanimously allows the appeal. Lord Hamlin and I give the judgment with which the other justices agree. The court considers that the Court of Appeal was wrong to say that other CAD applications or decisions have to be ignored entirely, as if they had never been made. It is legitimate to refer to them as a source of information capable of bearing on the relevant question to be addressed under the statutory compensation regime. That question is whether, at the valuation date, planning permission in relation to particular forms of development could reasonably have been expected to be granted for the parcel of land for which compensation has to be paid. If CAD applications or decisions are capable of being a source of relevant evidence bearing on that issue, the 1961 Act does not preclude reference being made to them. In real-world situations, there is a detailed set of rules which explain how an application for planning permission for development of one parcel of land in a particular way may be affected by applications which are made or may be made for planning permission for similar development on other parcels of land nearby. For example, if there is a public need for a particular form of development in the local area on only one site, a judgment is made about which is the best site, and planning permission for that development will only be given for that site. Planning permission for such development will be refused for the other competing sites. The compensation regime under Section 14 of the 1961 Act requires a set of assumptions to be made about the position as at the valuation date. These include taking account of any planning permission that actually exists at that date for development of nearby land. They also include having regard to circumstances known to the market at that date. In the Court's view, market participants would understand how the detailed rules governing grant of planning permission for particular forms of development between competing sites operate. This is not to say that an application for a CAD is the same as an application for planning permission in the real world. They are clearly different and arise in different circumstances. However, market participants would appreciate the inherent development potential of parcels of land in a particular area and would also appreciate how the planning system would be likely to resolve competition between them. Therefore, the compensation regime under the 1961 Act has to take account of these matters. It is not correct to look at each application for a CAD as though the parcel of land to which it relates stood in isolation. So, for example, if there were a development opportunity in the area which was particularly valuable, and in the real world planning permission would only be granted for it on one parcel of land, it would be wrong to approach the assessment of compensation for the 4 parcels of land on the footing that each of them could have been used for that development. In line with this reasoning, the Supreme Court gives guidance for the lower courts and tribunals and for local planning authorities about how they should approach their task in assessing what counts as appropriate alternative development for the purposes of the 1961 Act.
Thank you. Court is now adjourned.